Okay, I want to welcome you to the Mid-Michigan Understanding Expungement and Resources to Assist Applying for Expungement presentation. My name is Allison Hudson. I'm the site manager for the Mount Pleasant and Midland offices. There'll be an opportunity for you to ask questions at the end of the presentations, or you can also type into the question and answer boxes. So just a few housekeeping items before we start the presentations. Please exercise patience, especially with technology. Zoom should default to live transcript, but you can go to the live transcript button to either access or hide subtitles. There's also an option to view full transcript. There is a designated time for questions and answers at the end of the presentation by each speaker. To ask questions in the Q&A, press the Q&A button at the bottom of the Zoom interface. Captioning is available by pressing the closed caption button inside the Zoom application and choosing Show Subtitles. So I'm going to turn it over to Amy Mylink. Amy has worked at Legal Services of Eastern Michigan since 1991. She handles and supervises cases in family, consumer disability, public benefits, and housing law and expungement. She is a past board member for a dispute resolution center and volunteer for a domestic violence shelter. She works in the community to encourage private attorneys to volunteer their time on a pro bono basis.
Thank you, Allison. Good morning, everyone. I'm going to go through my presentation about the basic eligibility requirements for setting aside the conviction. Won't be going into a lot of detail about the process, just an overview of that. So let's get started. Allison, do you have my first slide ready, or am I sharing that?
Yes, can you see it? Sorry.
I cannot.
Let me see what's going on here. I see it on my end. Let me try to reshare it.
I can see it now. Thank you.
Okay, you're
I
welcome.
just wanted to make sure everybody else could see it as well. So thank you. The law for setting aside convictions in Michigan changed in April 2021. The new law allows for a greater number of convictions to be set aside than in the past. However, there are still limitations and eligibility guidelines. As I said, this presentation will give you a brief overview of what may be allowed to be set aside. The information provided will be general and may not answer all your questions. If you have questions about your eligibility, you should review your complete criminal record with an attorney. And I will say, if you have questions today about your specific situation, we're really not going to be able to answer those without seeing your specific criminal history. We can answer general questions only. So the next slide, please. Types of convictions that can be set aside in this process. You will have to determine if and under what circumstances they can be set aside. The types of convictions determine how long you have to wait before you can request to have any convictions set aside. There are laws related to marijuana convictions, misdemeanors, felonies, and special rules for assaultive crimes. In February 2022, some convictions for operating while intoxicated became eligible to be set aside. However, there are also some convictions that can be never set aside, and that's what our overview will be. Next slide, please. Because marijuana is now legal in the state of Michigan, many convictions related to marijuana can be set aside. These include marijuana convictions related to possession and use of marijuana, and selling marijuana paraphernalia. The process for this part of the expungements is quite simple. It does not require a waiting period and does not even require a court hearing. In 2023, this year now, these convictions should automatically be removed from your record. That process is supposed to start, is our understanding, in April of this year. We haven't gotten confirmation that it will actually happen, but that is the goal. Next slide. A misdemeanor is an offense where the maximum prison time is less than 90 days and the maximum fine is less than $1,000. A person can apply to have most misdemeanors set aside, including traffic offenses. However, you should understand that traffic offenses expunged from your criminal record does not affect your driving record with the Secretary of State. So those things like traffic tickets, violating a traffic signal, and other traffic offenses just will not be removed from your driving record. And that may not be relevant to the job you're applying to, but if you are applying for a job where they require you to have a valid license, and you may have that, and they want to see your driving record, those things will still show up on your driving record, even if they were removed from your criminal record. The waiting period to have a misdemeanor set aside is 3 years after the end of the sentence. We're going to go into more detail about how you determine that waiting period a little later. Next slide. There are something called serious misdemeanors, and this is a special category. Under the set-aside laws, there are a specific list which includes many assaultive crimes, domestic violence, some firearm charges, stalking, neglect or delinquency of a minor, fourth-degree child abuse, and some vehicle injury and operation charges. Serious misdemeanors can still be set aside in most circumstances, but a person has to wait 5 years from the end of the sentence rather than the 3 years with a regular misdemeanor. Next slide. Felonies are the most serious types of convictions. The minimum sentence for a felony is usually over 1 year or longer, and the fines are higher than misdemeanors. A person with more than 3 felony convictions is not eligible to have any convictions set aside except for those marijuana convictions. So if you have a combination of 3 or 4 felonies and some misdemeanors, you are not eligible to have any of those set aside unless some of them were related to marijuana and fell under that exception. The waiting period to have a felony set aside is also longer. If you have only 1 felony conviction, you have to wait at least 5 years. And if you have 2 to 3, you must wait at least 7 years from the end of your sentence. If you have felony and misdemeanor convictions, the waiting period is determined by the felony waiting period. Again, we're going to go into more detail about that. Next slide. If someone has more than 3 felony convictions, they may be eligible if more than 1 conviction occurred from the same incident. So again, I'm going to generally say if you have more than 3 felony convictions, you're not eligible to have anything set aside except under this very, very limited exception. This is very special and fact specific, and it's known as the 1 bad night rule. For multiple felony convictions to qualify under this rule, they must occur in the same 24-hour period and arise from the same set of events. None of these convictions can have a maximum sentence of more than 10 years, involve any assaultive conviction, or involve any dangerous weapon conviction. Very few people qualify under this exception. So if you have more than 3 felony convictions, it's likely that you're not eligible. But this is something, if you have 3 felony convictions in one day, or under one case, it is worthwhile to review it to see if you qualify for this exception. But again, very facts specific. Next slide. So I talked about assaultive crimes having some limitations, and assaultive crimes can be either misdemeanors or felonies. And these types of crimes have special rules. A person can only have 2 assault convictions, whether misdemeanor or felony, set aside. And this is a lifetime limit. If a person has 4 assault convictions, they could apply to only have 2 of those set aside. So if you have several assault convictions on your record, under the current law, you will always have some convictions left after an expungement. Assaultive crimes include crimes involving a dangerous weapon, domestic violence, resisting and obstructing an officer, and any type of assault or assault and battery. If you have assault convictions in other states or federal convictions, these will be considered when determining how many you can have set aside. Next slide. So as I said, the law for having operating while intoxicated convictions did change just about a year ago. Took effect on February 23rd, 2022. And with this change, a person who has only 1 OWI conviction may be eligible to have it set aside. It is not a guarantee. If the person has more than 1 OWI conviction, they are not eligible to have any of the OWI convictions set aside at any time. Also, if the conviction resulted in serious injury or death or child endangerment, even if it was only 1, but it resulted in any of those things, it could not be set aside. If the OWI occurred while operating a commercial vehicle or with a commercial license, the conviction shall not be set aside. Judges will be giving these requests extra scrutiny, and the court can consider whether or not the person has benefited from rehabilitative or educational programs. So rehabilitative programs might be doing substance abuse counseling, and actions like that. You should also know that any OWI that is set aside, again, will still remain on your driving record with the Secretary of State. Next slide.
Amy, we have
Yes.
a couple of questions. Do you want them at the end or do you want them as they pop up?
I think I prefer them at the end, please.
Okay.
Thank you. So there are certain convictions that cannot be set aside. And that means never. These can never be set aside. It doesn't matter whether a person just took the plea instead of going to trial. It doesn't matter the circumstances under which the conviction occurred. They just can't be set aside if you have this type of conviction. This includes criminal sexual conduct convictions, 1st, 2nd, and 3rd degree, including convictions for attempted CSC. Criminal sexual conduct convictions, 4th degree, if the conviction was after January 15th, 2015. 1st and 2nd degree child abuse. Convictions involving soliciting minors or involving child sexually abusive materials, and felony convictions for domestic violence when there is a previous misdemeanor conviction for domestic violence. So again, very fact specific. Some of those may not be as clear as others, and that's when you would want to have your record reviewed. Next slide. The additional convictions that cannot be set aside are any felony that is punishable by life in prison, including murder, attempt or solicitation of murder, torture, carjacking, and armed robbery, kidnapping, and others. These are considered capital offenses. You can also not set aside violations for human trafficking, terrorism-related offenses, and offenses for using a computer to commit sex crimes. Next slide. Some people may have deferred and dismissed convictions. This is a conviction where the offender met certain guidelines and was eligible to have that conviction deferred or dismissed. Basically, it was taken off their record. A lot of these include people who participated in what's called a HIDA program, the Homes Youthful Offender Trainees Act, possessions for controlled substance, minor in possession, completion of drug or veteran courts. Many courts are developing special courts for people that are veterans or that have convictions for drug, realizing that that population may need different resources and support to be successful, but then also recognizing that if they are successful with those completions, then we want to get the conviction off their record. And then other provisions as designated. Basically, it means the conviction does not show up as a conviction, and it shouldn't show up on your record to employers. But why it's important in this process is if you have ever had a conviction deferred or dismissed, it can affect your eligibility to have other convictions set aside. So it may not show up on your criminal record when an employer looks at that, and it has been deferred and dismissed, that's correct. But if it gets to the question of, have you had an assaultive crime set aside? If you had one deferred and dismissed, and now you have two more, you're only eligible to have one of those set aside because you essentially had another one set aside. Again, fact specific, but if you know you've ever had a conviction deferred or dismissed, that is something to discuss and bring up with any attorney you talk with. So the waiting period. As we've discussed, the waiting period to file an application to set aside a conviction depends on the type and number of convictions that you have. Also, as indicated, the waiting period only begins after the end of sentence or probation, and this can include payment of restitution. In all cases, the waiting period refers to whichever event occurs last. The best way to talk about this is looking at some examples. So next slide, please. Oh, next slide, please. Sorry. So example one, Linda was sentenced on March 18th, 2021. She was ordered to be on probation only for 6 months and pay restitution of $500. And this is a misdemeanor. Her probation ends on September 18th, 2021, and she's paid all of her restitution. Her waiting period begins on September 18th, the end of her probation, not on the date that she was sentenced, but the end of her probation. So she would be eligible, if this is the only thing on her record, 3 years after September 18th, 2021, and that would be in 2024. In example 22, let's assume Jim has 2 felony convictions in 2012 and was released from probation in May 2015. He also has a misdemeanor conviction in 2017 and ended probation on November 12th, 2018. Jim is eligible on November 12th, 2025. The controlling wait time for Jim is based on the felony convictions. So as I said before, the waiting period when there are 2 felony convictions is 7 years from the last event, and the waiting period starts at the end of the probation for the last conviction. And even though that last conviction was a misdemeanor, the 7 years doesn't start ticking until after the end of that probation. Next slide. So there are some other final considerations. If you owe any outstanding restitution, generally this payment must be paid in full prior to filing your application to set aside a conviction. If you're with regard to that, if you owe some court fees and are making payment to the court, a judge may consider it if not all those fees have been paid. If you owe a victim restitution, the court's going to want to see that paid before considering setting aside any conviction. Just generally, the best advice is to have those things paid before filing your application. If an application and your request is denied, you must wait a minimum of 3 years before filing another application, unless the judge orders a shorter time period. Remember, having a conviction set aside is a privilege and it's not a legal right. It can be denied by the courts. So if you go in and you ask for a conviction to be set aside and the judge indicates maybe there's some error or something, doesn't believe you've been completely rehabilitated. If you don't request, the judge will just deny it, and that's automatically 3 years. You could ask the court to consider a shorter waiting period. And the court could say, okay, come back in a year, but I want to see that you've done X, Y, and Z. And, but if you don't bring it up, they're just going to deny it, and it's automatically going to be 3 years. Lastly, if you have any criminal charges currently pending, you are not eligible to apply to have any convictions set aside. It doesn't matter if your waiting period has expired. The fact that you have criminal charges currently pending puts a hold on everything. Now, if those charges were dropped, you could then proceed. But if you have that conviction, the clock has restarted again. Next slide, please. So as I already indicated, one of the changes in the law is that many convictions will automatically be removed from your record after the waiting period. And this is supposed to happen sometime after April 2023. It's taking some time to build the system to make sure it happens correctly. And it will only happen after the predetermined waiting periods have passed. We're going to be keeping our eye on this because we don't know how well it's going to go. This is a complicated reporting system because there's, as you can imagine, many courts around the state. There's 88 counties, and those courts have to report to the Michigan State Police, who keeps the criminal histories. Not all courts report, so the information they have may not be accurate. So courts still have to come up with a way for the automatic expungement. And not all crimes or convictions are eligible for automatic expungement. There are limitations to that. So there may be crimes that you could have a conviction for that you'd still have to go through this process. OWI would be one of them. Okay, so briefly, I'm going to talk about how to set aside a conviction. And when I say briefly, I mean briefly. The one thing we tell people to start with is next slide, please. You have it, thank you. Is getting a copy of their Internet Criminal History Assessment tool, which we refer to as an iChat. Your local Michigan Works may be able to help you get a copy. Otherwise, you can go online, and resources that will be provided to you has that address for how to access that information. There is a cost of $10. You also may need to get a copy of your judgment of sentence for every conviction you want set aside. These judgments can be obtained from the clerk's office in the county where you were convicted. Each judgment costs between $10 to $12, depends on how many pieces of paper that it generates, but you may need those. Next slide. You also need a fingerprint card completed at your local sheriff or state police. There is often a charge for this service, and it can vary from department to department. You need application to set aside conviction form. You should be able to obtain this form from the clerk's office. So if you were to go in and purchase your convictions, the judgment of convictions, you could ask them for that form. That's one way. There's no fee for the form, and there's no fee to file the application. Eventually, you would also need a check for the Michigan State Police of $50 to do a background check. Next slide. After gathering these items, you complete your application, you file it in the county where you were convicted, and there are instructions that come with the form telling you how many copies you need. You will usually be given a hearing date that is 2 to 3 months, and more realistically, because of the number of requests and how flooded the system is, it's probably going to be 4 to 6 months after you file your application. After it is filed, you have to send it to the Michigan State Police, local prosecutor, and the Michigan Attorney General. Again, the instructions that come with the form tell you how to do that. Next slide. As long as your record comes back clean from the Michigan State Police, that means that it matches what you put on your application. You proceed to the hearing date. If something else came back on that conviction record that is not in there or can't be set aside or affects your eligibility, then that can cause delays or may make you ineligible. If everything's good, you go for the hearing in front of the judge and ask the judge to set aside the conviction. The judge may want to hear about how your life has changed and how having this conviction on your record is holding you back from getting ahead. Most judges are inclined to set aside convictions. They know mistakes happen and that people should be given a clean slate. However, it is up to the judge to grant or deny the request. We generally have been helping people do this and go to the hearing on their own. We prep people for it, tell them what to expect, do a little bit of hand-holding, but we are not going to the hearings. And again, as I indicated, judges want to grant these requests, and we hear very few denials. Every judge that I have talked to since the law has changed is very encouraged by it and really do want to help and make sure that people that can get expungements get them. So I know going to court can be intimidating and scary. If you have a conviction, the last time you were there, it may not have been a very nice process. This is the good part of court, and the judges like being able to grant these expungements because they do know it will help somebody. Oh. Last slide, and we can leave this one up while I'm answering questions because it does have resources. I believe this is going to be made available as well. So I know that one address's link is very long, and you may not need to write that down. So I see there are some questions. Does the set aside and expungement mean the same thing? Yes, it does. If somebody has an OWI and a DUI conviction, would they be eligible to apply? It's generally the same thing, and so it would have to look at it, but likely not. There's a question about high BAC OWIs. Under this law, an OWI is a OWI. I don't recall anything in it that distinguishes between whether it's a high BAC or not. And a high BAC is a blood alcohol content. It's just whether it's an OWI. Now, again, the judges are going to give these a lot of scrutiny. So if they see from the record that it was a very high BAC, that may be something to discourage the judge from granting the request. But a person can only have one of these on their record. And so imagine a situation where somebody had a high BAC 20 years ago and never had anything else. I think a judge is generally going to, if I were a judge, I consider that person reformed and want to grant it. These rules and the process that I just described only apply to Michigan. Every state sets their own rules about what can be and should be and will be set aside. So anything I've talked about today is Michigan law and only applies to Michigan convictions. If somebody has federal convictions that happened while living in the state of Michigan, that is still a federal conviction. This process does not apply to it. The PowerPoint presentation will be made available and limited. We don't put it out for public, just put it out to the public generally because things do change and we don't want it to be disseminated too widely that we can't control updates and making sure that the correct information at the time is available. When somebody asked, can you take care of more than one conviction at a time? And absolutely, particularly if they're in the same county, they can be put on the same application. This process actually contemplated that and makes it easier to do that. If they're in different counties, you have to file applications in the individual counties. But if you have multiple convictions in one county, that can all, well, if there's district court and circuit court, those require different applications. But imagine somebody who only had misdemeanors in Saginaw County, those could all be done with one application. If somebody, there's a question if on a job application, if there is an expungement of the offense, do you have to answer, well, if there's been an expungement, then that conviction is removed from your record. For LSEM, legal services, if we help with it, there is no charge if you're eligible. We're doing very limited help right now just because of the great number of requests we've had in the past year, and we're still processing those. And I know there's limitations on this whole presentation. So if we need to stop and let the next presenter proceed, please let me know, Allison. Okay, not hearing anything.
I'm not sure who's keeping time.
I just see that we're 11:34, so.
Maybe we can move on to the next presenter and have maybe Amy, you could answer the questions in the chat. And so everyone can save that if they'd like.
I can do that. Thank you.
Thanks.
Hi, Anna. We're unable to hear you at the moment. We can see your mouth moving. And it looks like you are taken off mute, but unfortunately, we are unable to hear you for some reason.
Okay, I would like to now introduce Anna Willman Onstadt. Anna is a programs director for Great Lakes Bay Michigan Works, overseeing the provision of services for ESTAA and business services in Bay, Midland, and Saginaw counties. She has worked in workforce development for over 25 years as a direct service provider, team leader, and manager in 6 counties.
Anna, you may want to take just a few seconds to log off and log back in and just make sure that you enable the computer to use your audio.
Allison, while we're waiting, I see that the presentation is not in presentation mode.
Yeah, and maybe while we wait for Anna to log off and log back in, we could go ahead and answer some of the questions that were waiting from the
Perfect.
previous presentation.
I was going to ask you if you wanted me to do that. Somebody asked if a conviction is set aside, will your criminal history show that you have something that is set aside, or will it be wiped clean from your record with no evidence of any past convictions? It never all goes completely away. There are still, like, law enforcement agencies can still see that information. It can still be seen or maybe relevant if somebody is applying for licensing, for maybe being a nurse, being an attorney. That is still available to be seen in that way. So no, does it completely go away? No. But it is from the general public and from employers. Most employers search your criminal history through that iChat tool that I talked about. And that is what we're attempting to clean up. There are some employers that could be more aggressive, and it depends on the higher level of security and trust involved with your job. So somebody like a nurse or a doctor or a lawyer, where there's a high degree of trust and care put with vulnerable people, that your record can still be seen for that. What they're generally may be looking for is, did you have fraud? Did you take advantage of somebody? Those all can be relevant still. Do you have a assaultive behavior? So it doesn't completely go away, but for the general public and for most employers, that iChat will be clean. Somebody asked, how long does it take for it to come off the iChat? And we have been checking these, and we're seeing in some instances, it's about 30 days. This is dependent on the court where it happened. What happens after the hearing is the court clerk is required to send a copy of the order setting aside the convictions to the Michigan State Police, and that prompts the Michigan State Police to take it off of your iChat. What we're finding is not all courts are doing that or doing that as quickly. We, unfortunately, don't have control over it. The person who asks for the application doesn't have control over it. We are trying to monitor those for people that we're working with and follow up with the clerks. But if the clerk does their job and they send it in as they're required, Michigan State Police seem to be getting it off in 3 to 4 weeks. That was really all. There are a couple that I'm going to type answers to, because they're very, very specific. But that's all the questions I have to answer at this time.
Thank you, Amy.
Was Anna able to rejoin?
I don't see her listed. Have you gotten any emails from her?
No, it looks like she dropped off to log off and log back in. I don't know if you want to maybe take a quick break and see if she joins in. Otherwise, I don't know if you need to end the presentation early, if she's unable to make it work. Kind of leave that up to you guys.
I could go through her slides because we're working in conjunction with them, and that's what this presentation was done. And I don't know that I can answer specific questions, but we could go through the slides still, I think, if need be.
Okay, that sounds good. And then maybe if she joins in and is able to speak at that point.
Okay. So we started a program after the law changed back in 2021 to help people go through this process. And it's been a great partnership with Michigan Works Great Lakes Bay region. Not all Michigan Works offices, it's just our local one. So they are helping. Can you go to the next slide? So they completed an interest form that I believe is on their website still, and job seekers or anybody working with Michigan Works could go fill it out. If you're not working with Michigan Works, I think they do have a process where they want you to sign up to work with them, but this could be the only thing that you're working with them on. Next slide. So you also could complete the application packet at any one of their local centers that are listed there. What Michigan Works was doing then is they were running the iChats, and based on the basic information they gathered, then they would give it to us, and as their legal partner, we do the legal assessment. Some people were able to tell right away, you're not eligible, and tell them maybe when they may be eligible or that they're just not eligible at all. So we do try to convey that legal advice. Next slide. If we determine that somebody is eligible working with Michigan Works, we or they will contact them. And we held some large clinics in 2021, very large clinics, and they created a lot of clients for us, and we're still working on those cases. But we have hired an attorney to be working on these, and so we're starting to do some more individual work. So if you go through this process, they will get us the information, and we are processing those as quickly as we can with the limited staff and resources that we have. Next slide. Again, as I already said, if you're not eligible or not yet eligible, that information will be conveyed to you. Sometimes it's through the Michigan Works staff member. Sometimes it's through our office. It just depends. We want to tell people as quickly as possible. Next slide. And then if there's questions, there's their general 800 number. And they also have a very specific email, cleanslate@michiganworks.com. Again, that's cleanslate@michiganworks.com, where questions can be emailed about it. If you call the 800 number, then you would indicate you're calling about the Clean Slate program. Michigan Works has been helping cover some of the fees that I discussed were involved. Again, you would have to be working specifically with Michigan Works to be eligible for those, but that can be a benefit to you. That's really all. I know I don't want to give anything else that may be too specific, other than the work that we're working with them on.
So it's 11:46. There's about 15 minutes left of the presentation. Are there any more questions that need to be addressed?
Looking at this, I have a few that I will address individually, but I think I've been watching it. I haven't seen anything else that I think I can address.
Allison and Lori, are there any more closing comments you'd like to make before ending the presentation?
The questions that have been asked, I guess there's probably a way that we can answer those questions and email them out to the participants. Is that right, Cami?
No, we don't collect email addresses. If
We
folks
don't.
put them in, it might be possible, but since they're not required, we can't ensure that any participant, that particular participant has added their email address.
Okay, but they can come back and look at the answers if they're typed in.
Yep, so if you type them in, they'll become part of the transcript.
Okay, so we're sorry about that. We had some technical difficulties. We will get answers typed in, and then sounds like you can come back and review this as part of the transcript, so you can then have answers to your questions that you've posted. Is there anything else, Allison, before we wrap up?
I don't think so. I just want to thank everyone for attending the Mid-Michigan District's First Friday event.
It looks like Amy has a question.
Well, I saw a couple more questions come in, and I just, if we had time, wanted to address them quickly.
Sure.
One is, if a conviction automatically drops off, will the person be notified? And no, you're not notified. The way you check to see if it's automatically dropped off is running the iChat and seeing if that has cleaned up. Again, I wouldn't start doing that to see if one automatically drops off, because the system is not built for that. That is not happening yet. That's going to happen sometime later this year. And then there's, again, the question about out-of-state convictions. This law only applies to convictions in Michigan, has nothing to do with convictions in other states or federal convictions. I think that is it.
Okay. Well, we want to thank our presenters, and I thank everyone for taking time out of their day to join us for this presentation today. And the PowerPoints that we had discussed, I think the portions of them that we're able to, they'll be also, I'm guessing, put into the chat so it becomes a part of the presentation. Is that how that works, Cami?
No, if anybody wants a copy of the presentation and you're willing to share, you'll have to provide some contact information for who they should contact to get a copy, and then you could email it out to them directly.
Okay. If we put that email address into the chat, then we should be able to, everyone should see it then, correct, Cami?
Sure. Yep. Or you can state it here and it'll become
Okay.
part of the transcript, and they can go ahead and grab it from there as well.
Okay. I guess, Allison, I'll go ahead and give mine, even though mine's the longest one probably. It would be Crawford Milbrot, CrawfordMil, B as in boy, ROTL @michigan.gov. And then I will make sure that we can send along anything, or at least try to send along anything that you're requesting. Okay, thanks again. And we appreciate everyone's participation and the great questions.